There's a big college affirmative action case on in October. You've probably read about it. This is the latest iteration of a very old question. Can the government, in this case a state university, give an advantage to a student because of his or her race, to give sort of an edge to Black or Hispanic students in the interest of diversity, changing the university, or does that violate the rights of a white student who says, I was denied the equal protection of the laws? The interesting twist in this case, and what you really should watch, is the question of the so-called race-neutral alternatives. About 15 years ago, 1997, a federal appeals court in Texas had said, you may not use race for affirmative action at the University of Texas. The state legislature, a Mexican-American woman in the state legislature, sponsored a bill, eventually passed, signed into law by then Governor George Bush, that said the state is going to grant automatic admission to its public universities, including UT Austin, for the top 10% graduates in all of its high schools all across the state. And this really transformed education in Texas. Now, Mexican-American kids in the Rio Grande Valley, African-American students in Houston or Dallas, rural white kids across Texas suddenly had an opportunity to go to UT Austin. And over time, the percentage of minority students coming into UT Austin steadily rose. A classic race-neutral alternative. That is, those kids were getting in because they did very well in high school. But in 2004, after the Supreme Court had narrowly upheld race-based affirmative action in the University of Michigan case, Texas announced that they were going to go back to using race, but for a very limited part of the class. It's only about a quarter of the freshman class. So 3/4 of the kids come in under the race-neutral plan, it's now called the top 8% plan. They've scaled it back a little bit. 1/4 come into this under this so-called holistic review, where the university says, we're going to consider a whole lot of things about a student. We want to be able to have some discretion to pick our students. And the university says, if we get a kid who's interested in architecture or music or plays the oboe, we want to be able to choose that kid. So they are now defending the use of race for a limited part of the class. So this is how the case arises. After that happens, a young woman named Abigail Fisher was turned down in 2008. She's a white student, Sugar Land, Texas. Strikes me as a good but not excellent. She had good grades but not excellent grades. She didn't get the top 10% of her class. And she's the kind of student who could have got in, but as I say, was turned down. So she sued and says, I was discriminated against. I wouldn't think she'd have a very strong claim, but she is able to say, Texas has a process where race plays a role, and therefore I was discriminated against. The Fifth Circuit, the federal courts in Texas upheld the Texas policy because they said, well, look, the Supreme Court has already said in the Michigan case, you can consider race in a very limited way. Texas is doing that. But the Supreme Court then granted it, and this is a really interesting case because the middle vote now is Justice Kennedy. It used to be Justice O'Connor. She's gone. Justice Kennedy has dissented in every affirmative action case, every race case, but he said in 2003...
Dissented in all of them upholding the programs.
Pardon me?
Dissented in all of them upholding the program.
Yes, he's always opposed any use of race. But in 2003, in the Grutter case, he wrote that he could accept Justice Powell's notion, going way back, that a university could consider race as one modest factor, but then he said, before we approve a race-based admission scheme, that was his phrase, we should seriously force universities to consider race-based alternatives.
Race-neutral alternatives.
I'm sorry, race-neutral alternatives. So that's essentially where we are now. That is, here's a situation where Texas has a race-neutral alternative that's brought a significant number of minority students in. The university is saying we should be able to go further and consider race. One thing that surprised me, and I was down to Texas and talked to people about the case, is that overwhelmingly the minority students who come into Texas come in under the automatic admission. It's been 9 out of 10 in some years. And in 2011, 36% of the kids who came under the automatic admit were Hispanic or Black. Under the holistic review, it was about 17 or 18%. So Texas is actually, the minority students are actually doing much better under the automatic review policy. So I don't know what the court's going to do with this, but I think the really interesting thing to watch is if Justice Kennedy and the conservative justices say something like, you as a university can't have a race-based affirmative action plan if a race-neutral policy could work. And that would be, could have an interesting impact around the country. You could write an opinion that's a Texas-only case. Some people say Texas is the only one that's had this much success. But it's the real interesting twist to watch in that case.